South Carolina. What is this? Section 12, 21, 5020 of South Carolina law provides definitions. South Carolina law reads as follows. Marijuana means any marijuana, whether real or counterfeit, as defined in Section 4453-110, that is held, possessed, transported, transferred, sold, or offered to be sold in violation of the laws of this state. 2. Controlled substance means a drug or substance, whether real or counterfeit, as defined in Section 4453-110, that is held, possessed, transported, transferred, sold, or offered to be sold in violation of the laws of this state. Controlled substance does not include marijuana. 3. Dealer means a person who in violation of the laws of this state manufactures, produces, ships, transports, or imports into South Carolina or in any manner acquires or possesses more than 42 1/2 grams of marijuana, or 7 or more grams of a controlled substance, or 10 or more dosage units of a controlled substance, which is not sold by weight. 4. Department means the South Carolina Department of Revenue. This is found in Title 12, Chapter 21, Article 25, of the South Carolina Code of Laws. This article may be cited as the Marijuana and Controlled Substance Tax Act. The Marijuana and Controlled Substance Tax Act became law in 1993. See 1993 Act No. 164, Part 2, Subsection 78. South Carolina Code of Laws, Section 12, 21, 5030, reads as follows. Department to administer article, collect taxes. Dealers not required to give identifying information. The department shall administer the provisions of this article. Payments required by this article must be made to the department on the form provided by it. Dealers are not required to give their name, address, social security number, or other identifying information on the form. The department shall collect all taxes under this article. South Carolina Code of Laws, Section 12, 21, 5090 reads as follows. Tax imposed. Rate. A tax is imposed on marijuana and controlled substances as defined in Section 12, 21, 5020 at the following rate. 1. On each gram of marijuana, or portion of a gram, $3.50. 2. On each gram of controlled substance, or portion of a gram, $200. 3. On each 50 dosage units of a controlled substance that is not sold by weight, or portion of 50 dosage units, $2,000. South Carolina Code of Laws, Section 12, 21, 6010, reads as follows. Stamps, labels, or other indicia to be purchased from department at face value. Official stamps, labels, or other indicia to be affixed to all marijuana or controlled substances must be purchased from the department. The purchaser shall pay 100% of face value for each stamp, label, or other indicia at the time of the purchase. South Carolina Code of Laws, Section 1221, 5050 reads as follows. Dealer not to possess taxed marijuana or controlled substance without evidence that tax was paid. No dealer may possess any marijuana or controlled substance upon which a tax is imposed unless the tax has been paid on the marijuana or other controlled substance, as evidenced by a stamp or other official indicia. But wait. The South Carolina legislature placed a roadblock within the same article. South Carolina Code of Laws, Section 12, 21, 5060, reads as follows. Nothing in this article may provide immunity for a dealer from criminal prosecution pursuant to the laws of this state.
Legal disclaimer. Note, I am not a lawyer. The information I provide is for general informational purposes only and is not intended to constitute legal advice. Therefore, you should not act or refrain from acting on the basis of the information I provide without first seeking legal advice from counsel within your relevant jurisdiction. Only your individual attorney can provide assurances that the information contained herein, and your interpretation of it, is applicable or appropriate to your particular situation. Any and all liability, with respect to any and all actions taken or not taken based on the information I provide, is hereby expressly disclaimed, for I am the rebellious one.